Chapter 8 of Indian Contract Act of Indemnity and Guarantee, right from section 124 to 147, in which one of the following consideration is not required. Contract of bailment. In which among the following cases the COT is not discharged? Answer: contract between the creditor and the third person is given person to give time to the principal debtor. Indian Contract Act, a contract of insurance is a contract of indemnity. Which one of the following is not true about a warranty? It is applicable to service only. A contract between the insurance company and the vehicle owner to save later from consequences of vehicular accident is called contract of indemnity. Contract of insurance is a contract of indemnity. Section 124 of Indian Contract Act includes under contract of indemnity the losses caused by human conduct. Which one of the following not essential of contract of guarantee? Answer: existence of only one contract is not an essential. Which one is essential are concurrence of three parties, COT distinct promise to be answerable, liability to be legally enforceable. Contract of indemnity is defined under which section of Indian Contract Act? Section 124. Contract of insurance is what kind of contract? Contract of indemnity. A contract by which one party promises to save the other from loss to him by the conduct of promisor himself or by the conduct of any other person is called contract of indemnity. Ramesh employs Suresh to beat Mahesh. Ramesh promised to indemnify Suresh against all the consequences of the act. Suresh beat Mahesh and has to pay damage to Mahesh for beating and committing upon him. Ramesh is not liable to indemnify Suresh for those damages. A and B go into the shop. B say to the shopkeeper, let him have the good. I will ensure that you are paid. This contract is a contract of indemnity. In which one of the following statement is incorrect? A stipulation in the contract of sale may be a condition of warranty. This one is right. A breach of warranty sometimes result into repetition of the contract. Wrong. B is wrong. Breach of a condition result into repetition of the contract. This one is right. So only B is wrong. Incorrect statement. X, a publisher of newspaper, agreed to publish at Y's request a defamatory article in respect of Z, and Y agreed to indemnify X against the consequences of the publication. In a suit by Z, X has to pay damage and incur expenses. Which one of the following is a correct statement regarding the liability of Y? Y is not liable to act was criminal. Which type of loss is not covered under contract of indemnity? Losses arises from accident like fire or perils of a sea. A contract to perform the promise or discharge of liability of third person in case of his default is known as contract of bailment. Indemnity holder acting within the scope of his authority is entitled to recover from the promisor answer is D. All of the above. All the damage which he may compelled to pay in any suit, all cost which he may compelled to pay in any suit, all sum which he may paid up under the terms and compromises of any suit. In a contract of guarantee under Indian Contract Act, the person for whom the guarantee is given is called principal debtor. A said to B that he was given a sum of rupee 5,000. If B marries his daughter, this is contingent right. A guarantee which the creditor has obtained by means of keeping silence as to material circumstances is invalid. Under which provision of Indian Contract Act the bank guarantee is governed? Section 126. A contract of guarantee has defined under Section 126. A continuing guarantee may at any time be revoked by COT as to future transaction by notice to the creditor. Mark the correct answer in respect of contract of guarantee. Both A and B. It may be in writing, it may be in oral. A sell and deliver good to B. C afterward without consideration agreed to pay for them in default of B. Agreement is void. The liability of COT under the contract of guarantee is coextensive with that of the principal debtor. A is COT for B for the loan of rupees 1 lakh which B defaulted. A is liable for rupees 1 lakh. The liability of the COT is coextensive with the principal debtor. It has been provided under Section 127. Section 128 of Indian Contract Act related to COT's liability. In a case of guarantee, the liability of COT is coextensive with that of the principal debtor. A becomes COT to C for B's conduct as a manager of C's bank. Afterward, B and C contract without A's permission that B shall become liable for 1/4 of the loss of overdraft. B allow a customer to withdraw and the bank loses sum of money. To make this loss, A is not liable. Extent of COT liability has been provided under section 128. Whether release of one co-COT discharge the other? No. A person who give a guarantee is called COT. A in the consideration that B will employ C in collecting the rent of B, Jamindari, promises B to be responsible to the amount of 5,000 rupees for the due collection and payment of C of those rent. This is simple guarantee. Liability of a guarantor is joint and several with the principal of debtor. In a contract, continuing guarantee is a guarantee extending to a series of transactions. Continuing guarantee is defined under section 129. What is the term used to describe guarantee which is intended to cover a large number of transactions over a period of time? Continuing guarantee. A continuing guarantee may be revoked by the COT by notice to the creditor as to the future transaction. A continuing guarantee under section 130 is revocable as regard the future transaction. A continuing guarantee may be revoked for further transaction at any time. The variancy of the contract without COT consent discharge him as to the subsequent transaction between principal debtor and the creditor. True. When a COT to the bond dies before the bond is forfeit, the liability in respect of bond shall be discharged. M lent 1 lakh to N. P is a COT. The contract provided that liability of P shall be limited to 50,000. The contract is valid. A guarantee can be oral or in written. A and B go into shop. B says the shopkeeper, let A have the good. I will see that you are paid. This is a contract of guarantee. A, B, C as a COT for D enter into three several bonds, each of the different penalty. Namely, A is the penalty for rupees 10,000, B is that for 20, and C is that for 40,000. Condition for D duly accounted to E. D make a default extend to 30,000. The liability of A, B, C are A, B, C are each liable to pay. Liability of COT and coextensive with the principal debtor unless it is otherwise provided by the contract. Any variance made without the COT consent in term of contract between principal debtor and the creditor discharge the COT as to transaction of subsequent variancy. Both are right and R is not correct reason for A. In which one of the following circumstances a COT stand discharge? Both A and B. By release of discharge of principal debtor, by variancy of the term of the contract. C advance to B attained 2000. The guarantee of A. C has also further COT of 2000 by mortgage of B's furniture. C cancel the mortgage, B become insolvent, and C sue A on his guarantee. A is not liable discharged from the liability. Contract Act liability of COT is conditional on default.